John, as you know, on online, the main question, or one of the main questions that we see, or I guess maybe not even question, but statements is, it's not the sheriff's job to interpret the law. It's for courts to do that, right? So why don't you go and explain to everybody what that means?
I know we all learned in the John Dewey public school model that laws are created by the legislature, and that the executive enforces the law, and that the judiciary interprets the law. If you can show me in the Constitution where it says that the judiciary is supposed to interpret the law, I'll accept that, but it's not there. Judges, when they take an oath of office under Article 6, Section 1, Clause 3, they take the same oath that the sheriff takes, and that is they swear to uphold and defend the Constitution of the United States. They don't have to interpret it because it's already been interpreted in 85 Federalist Papers. So, when the sheriff takes an oath to uphold the Constitution, he needs to know that anything that is repugnant to the Constitution is void. And there is no obligation by any law enforcement to enforce void law. Now, where I get this is they always say, well, it's the Supreme Court that has to decide what's constitutional and what's not constitutional. First off, we have to understand that the Constitution, the word Constitution means contract. The contract, the parties to the contract were the people of the several states. Those are the parties to the contract. The contract produced a product. That product was a federal government of 3 branches. Never in contract law anywhere does the product of the contract get to dictate the provisions of the contract. Only the parties to the contract can dictate the provisions of the contract. So the sheriff, in understanding that, understands that he has to look at what the very principles of the Constitution are. And under Article 6, Section 1, Clause 2, the very beginning of it says that the Constitution is the supreme law of the land, and for any other law to be as supreme as the supreme law of the land, it must be made in pursuance thereof, which means in spirit and form the same. Now I can demonstrate that between the U.S. Constitution and the Michigan Constitution very easily. Under Article 4, Section 4 of the Constitution, it says that every state must guarantee their citizens a Republican form of government. Republican form of government means there has to be a contract between the people creating the government. That's what we have in Michigan with the Michigan Constitution. Now, for that Constitution to be as supreme as the U.S. Constitution, it has to be in pursuance thereof. So, let's just take the Second Amendment. Second Amendment says a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Michigan has in Article 1, Section 6 that says everybody has the right to keep and bear arms for the defense of himself and the state. So you can see, even though they're not word for word, they are one is pursuant thereof the other. In spirit and form, they are the same. So farther down in Article 6, Section 1, Clause 2, it says, anything to the contrary in the constitutions or the laws of the state, notwithstanding. Now what that means, John Marshall told us what that meant in 1803 in the Mulberry versus Madison case, in which he said anything that's repugnant to the Constitution is void, and all judges in every department are bound by that instrument, thus showing us again that the people are freed by the contract of the Constitution, but all of us that take an oath are bound by it. So it's incumbent for your sheriff to understand those principles so that he can uphold the Constitution. Now what happens is, and what we've been doing since the progressive period of 1913 of Woodrow Wilson, is we hold the citizen guilty of whatever the legislature signs, because it's law. But is it pursuant thereof, or is it repugnant to the Constitution? I don't know, John. That's your business to take it to the Supreme Court, spend $150,000, $250,000 to find out whether it's going to go there. And oh, by the way, it's appealed by leave. If they don't want to take it because it's too political, they're not going to. And that's how we decide what's constitutional and not constitutional. That's not how it's supposed to be. As sheriff, I'm bound by that instrument. So I have to follow what I believe is constitutional by the principles and the 85 Federalist Papers that explain that Constitution to me in its very ideology. And then, if the governor has a problem with me doing that, then she can sue me. And I'll take it to the courts, because I have said I will defend the Shire. That's my job.